Hello, everybody. This is the Essentials of New Jersey Real Estate, Chapter 2, Dearborn. We're going to be talking about commission rules and regulations. This video has been a long time coming. If you've noticed from my first video, we didn't have as good audio, so you can hear me much clearer, and also the slides move. So thank you for everyone who was bringing that to my attention. I appreciate it, and I'm sorry that we didn't get this sooner. Without further ado, though, let's talk a little bit about having a real estate business. So what happened was we've already established in chapter 1 who needs to be licensed, what particular activities would trigger you to have a real estate license. We also discussed the different types of real estate licenses that there were and what those requirements were to obtain those licenses. So now what we're doing is we're venturing into, okay, I either want to work in a real estate office or I'm at a point where I want to go get my broker's license and I want to open up my own company. So the very first thing that we need to do is we need to establish the employment agreement, or the agreement between the broker of record or the broker and the salespersons and broker salespersons underneath them. So every single salesperson or broker salesperson that is working for a broker has to have some sort of agreement in place. So this is going to dictate the compensation rate that's going to be paid to that individual. Also, there's going to be built into that legally, they have to pay and turn over any money that is due to the salesperson or broker salesperson, excuse me, within 10 days of there being commission received, or as soon as a check is cleared. So every office is going to be different, but legally you have to be paid and compensated within 10 days of that commission coming in. So that's something that you really should know. I tell all of my students as a business practice, that's something you really want to keep tucked into the back of your mind, okay? Also, what happens too is this. We talk about the red carpet that we roll out for you as coming into a company. You're always warmly welcomed, all that kind of stuff. But also, you need to talk about, as soon as you start the relationship, you actually need to talk about what's going to happen when you leave. You need to talk about that red carpet when you leave, so that you understand, are you going to be able to take your business with you? Or are you not? How are you going to be compensated on any type of business that is either left over or that has yet to close? So there's a lot of things that are going to be in there. There's going to be a lot of minutia that should be hammered out in that agreement between the broker of record, and the broker salespersons or salespersons underneath their supervision. And also, this is binding to both of those parties. And I want to also mention this: you cannot be compensated by anyone for a real estate transaction other than your broker of record. That's basically, think of it as this. It is the multiply by zero question. Why do I call it the multiply by zero question? Because no matter how convoluted the question might get, okay, they might say, okay, you have a situation where there's a home for sale and there's going to be an Amex gift card. And this is something that normally happens, okay? There's a bonus of some sort. And that bonus is going to be something that would be given to the salesperson. Now, what happens is this: you can only be compensated by your broker of record. So if there was a bonus of an Amex gift card, if you sell it before Thanksgiving, and you went ahead and you did that, you produced a buyer before Thanksgiving, then what happens is you are entitled to that bonus. It is totally legal, but it has to go through your broker. And what happens is your agreement should have outlined what will happen in a scenario like that, where there is some sort of compensation that is outside the norm of, a straight monetary compensation. Maybe it be a gift card, maybe it be an item, maybe there's a car involved, maybe there's jewelry, something like that. And again, is that common? No. Does it happen? Yes, absolutely. I've actually sold homes that the seller was a jewelry dealer, and he actually offered, like a piece of jewelry in addition to the commission out there. So, yeah, I had something wacky like that. It had to go through my broker. My broker ended up just signing a letter and actually giving it to me. So that wasn't a problem. However, it's something that you cannot be compensated for by anyone except for your employing broker. Okay, so your broker of record is the only one that can compensate you. So whenever you see a question on the test, it's going to say something along the lines of, okay, you get this money, or you get this gift card, or you get this gift, and it's coming from someone other than your broker. Can you accept it? No, you have to go through your broker. That's, again, the multiply by zero. So think of it as any crazy math question that says you add this, you subtract that, you divide by this, and then you multiply by zero. The answer is zero. So think of the who can pay you question as soon as they ask you who can pay you, the answer is your broker, no matter how crazy the scenario is that got you there. Okay. Also, the salesperson cannot maintain a trust or escrow account. And in New Jersey, they cannot work for more than one broker at a time. So you cannot work for more than one broker of record at a time. Now, that's important because there are other states that do allow for that, such as, very infamously, New York. I personally worked for several different brokers in New York at the same time. I worked for a broker in Manhattan, and I also worked for a broker in Staten Island at the same time, because what happened was they didn't cross-pollinate in regards to their business, and the geographic size of New York State just lent itself to being a situation where there was always a need for there to be some sort of scenario set up where you would have to have dual licenses. So I know agents that would work on the Hamptons and then would come travel and would live in New York or Manhattan. And what happened was those were two very different geographic areas, but they wanted to work the same area. Also, I know people up in upstate New York that wanted to work downstate. So it's so big that they do allow for you to have what they refer to as dual licenses. Ultimately, it's just two separate licenses. One's held by one broker, one's held by another. In New Jersey, you do not have the luxury of being able to work for more than one broker at a time. So keep that in mind and just pick a broker that is going to be right for you. Now, we're going to talk about something called a trust or escrow account. And we're going to talk about what it is and also what you can and cannot do in regards to a trust or escrow account. So when you're establishing a real estate business, or when you're working within a real estate business, they're going to have the real estate office, and the company is going to have a trust or escrow account, whether the agents actively use it or they choose not to actively use it. Personally, me, as a business practice, I typically do not use a trust or escrow account because there's just more liability. And also, it's one of those situations that I typically have more things that could go wrong than could go right. And also, in New Jersey, I typically just pawn the deposits, earnest money, escrow holding off onto a attorney. So also keep in mind the trust escrow account cannot be interest bearing. This is not an interest bearing fund. This is a non-interest bearing fund. Okay. So the trust or escrow account is going to be used only for clients. This is only going to be for money received in there. So now there's also another question that they're going to ask you on the test. They're going to trick you with this one, where they're going to say, can a broker ever have their own money in the escrow account? Okay. And I will tell you this, if they have their own money in the escrow account, that is typically called commingling. And I said typically, okay? That is typically called commingling. So that should trigger a little thing in your head going, that is bad. Commingling is bad. That's the mixing of funds from operating expenses or general commissions or any money coming in that is not client related, okay? So if it's not client related, what happens is you cannot mix that with escrow, all right? There is one exception to that. And the one exception to that is that a broker is allowed to have in the escrow account whatever minimum amount is required in order to keep that trust or escrow account open. So whatever is required to keep that trust or escrow account open, okay, they can keep in there as personal funds, just to have it again open. They cannot keep anything above that. They cannot keep one penny above that. That would be considered commingling, and that is illegal. Okay. Now, records have to be kept of the trust or escrow account. Also, something that they don't mention on this slide is that the trust or escrow account, as soon as you receive a check that is intended to go into the trust or escrow account, that must be deposited within 5 business days. It's always business days because, again, we're dealing with banks, so it has to be during normal business hours. So if there's any kind of holidays or things like that that fall into place, then of course you would be relieved of counting that as a day. It was strictly business days that you would be going by. Okay, so that's it on the trust or escrow account. Now let's talk about the actual physical location of the offices, because there's a couple of things that we need to talk about in regards to the physical locations. So every real estate company is going to identify each of their offices as one of the following. They're either going to refer to it as a main office, okay? They're going to refer to it as a main office or as a branch office. So let's say my hometown of Freehold, New Jersey, okay? Also the hometown of Bruce Springsteen. Heck yeah. Okay, so my hometown of Freehold, New Jersey is where I'm going to put Stu's awesome, amazing real estate company. That is going to be where my main office is. Let's say I want to have an office also by the beach. I hear that Asbury Park is a happening, hip, amazing, up and coming town. I want to have another office there. So here's what happens. I can open up another office there. There are some requirements, though, about the physical space. And there's also some requirements about what has to happen in regards to supervision there. Okay. So at any of the offices, prominently displayed on the front door, front window needs to be the full legal name of the broker of record. So it has to say, let's say, again, we're talking about Stu's amazing, awesome real estate company. It will say Stuart J. Jacobson, broker of record or broker, okay? And it'll be prominently displayed on the front door or on the front window so that people who are approaching the business, people who are going to that place of business, understand who is the supervising broker. Okay, so that's at either a main or a branch office. Okay, so that's either going to be at my Freehold location, home of the boss, or my Asbury Park branch office, home of Danny DeVito. Okay, gotta throw that in there, right? So either one of those locations, that's what we have to have. Also, you have to have signage and an entrance that's going to be visible to the general public. Okay, so that's something that also has to exist. Another thing that I want to note, and they love asking this question, I don't know why, but they love this one. Can a main or branch office be located in the residence of a salesperson or a broker salesperson? The answer to that is no. The answer to that is absolutely not, okay? However, can it be located in the residence of the broker of record? Yes, if certain requirements are met, such as the office and living spaces are separate. There are separate entrances to both of those, okay? They don't share an entrance. And also that it still meets the requirements of there's a signage, visible to the general public, and there's also on the front door or the front window, broker of record, Stuart J. Jacobson, and that's for the whatchamacallit, that's for the broker of record signage that has to be on every single office, whether it be a main office or a branch office. Now, also keep in mind this. Your branch office locations, they also have to be supervised by a broker salesperson. So a broker salesperson has to be designated as the broker manager. Now, they're technically going to be broker salespersons because, again, they are brokers. However, in the capacity that they are working in a salesperson capacity under the broker or broker of record. Okay. So the broker manager, they're just there supervising that location. And why is that? So let me kind of go into that a little bit. The real estate commission, now obviously the practicality of real estate has changed in 2020. It's not the same as it was back in the day. However, how they view it is this. the main office has to be supervised by the broker of record. The broker of record is supervising that location, and they do not have more hours in the week than what a normal business would require. So they should be present at that office. And again, I understand the practicality of the fact that, hey, maybe you're not present at the office all the time. Maybe a lot of your agents are virtual. That's understandable. However, there still should be supervision. The real estate commission has an expectation of supervision if you're going to sponsor these people and be held responsible for what they do out there in the field. Okay, because that's ultimately what happens is the broker is responsible for what happens. Also, just as a branch manager is responsible for what happens at their offices, right? So you have a broker manager at a branch office. They're responsible for some modicum of what happens and what comes out of that office. Okay. So you have to have a broker salesperson at every branch office because the broker of record is overseeing the main office, right? So let's talk a little bit about record keeping and what we should see at our offices. Right now, just so you know, we're probably almost all digital. Okay. We're at a point where a lot of our stuff is completely digital. However, when we start going into, how long you have to keep contracts for, all that kind of stuff, we're going to get into really the need for there to be, some filing cabinets, some physical copies of things. Okay, because what happens is this: sellers, buyers, everyone who signs an original they are entitled to, at the signing of it, a duplicate original. Okay, so they're entitled to that. And again, electronic signatures create the opportunities for you to just basically email things out, and you just go click, 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 and everything's good. Also, another couple notes, and I don't know if it's on the next slide or on this slide, but I want to talk about the sales contract in regards to New Jersey, and I also want to talk about how long you have to keep things. Okay, so when it comes to the sales contracts in the state of New Jersey, you can fill out, as a real estate agent, you can fill out a pre-filled cookie cutter boilerplate template contract for 1 to 4 family homes and single vacant lots. Anything outside of that, you cannot write this pre-filled contract for. That would have to be basically maybe an offer to purchase, just a letter of intent to be sent out, and then attorneys would have to do that. Now, in New Jersey, we have on the cover page of any 1 to 4 family home and single vacant lots, okay, we have what is called Opinion 26. And Opinion 26 basically is a statement in a document that says, as a licensee preparing this document, we are not lawyers. You are entitled to seek a lawyer to review the contract, to make any necessary changes, and that's called an attorney review period. If you choose not to have that, and no attorney disapproves of the contract within 3 business days, it will become legal and binding. Okay, so typically what happens, and this is just how New Jersey rolls, basically Southern Ocean County and North, most people use attorneys 9 out of 10 times. Just Ocean County and South, they typically use just title companies to close, and they'll just use the boilerplate contract, and the real estate professionals, they'll be the ones to really kind of guide the clients through the transaction. Now, I want to kind of put a little thumbtack in that, okay? There will be questions on your test that will say, hey, here's a scenario. And you're studying for the real estate exam, so you might know the answer. You might actually be able to answer the question very eloquently, okay? I hope that after you watch all of my videos, you're going to sit there and go, I am super duper smart, and I can answer all these questions, so no problem. I know the answer. The answer would be, I would pick C. But one of the answers is going to say you should tell them to consult an attorney. You always, 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 always err on the side of consulting an attorney. If that's ever an option, that is your option. If it's ever an option, that is your answer, okay? Because you cannot be giving these people legal advice. And again, that's why we have Opinion 26 on the front cover of any 1 to 4 family home and single building lots that we prepare. It says on there, we are not attorneys. We cannot give you legal advice. And also, as a practicality, please do not give people legal advice. That is a quick way to get yourself into real estate jail. Not good. So now we're going to be talking about how long do we keep all these offers for? How long do we keep all this paperwork for? And I refer to it as the rule of 6. Okay. Unaccepted offers have to be kept for 6 months. Copies of contracts, sale listing agreements must be kept for 6 years. Basically, now that everyone's almost digital, we're pretty much keeping records for 6 years. It doesn't cost any extra money. It used to cost more money because we used to have to store it. We used to have to keep it on site. We used to have to do all these things. There used to be filing cabinets upon filing cabinets upon filing cabinets upon paper boxes upon paper boxes upon paper boxes. So it was a task. Like, I remember what the admin cost and what it used to take to run an office just to keep the records updated were massive, especially when we were in like hot markets and there was offers just being placed left and right. We had sometimes had paperwork coming out of the wazoo and we didn't even know what to do with it. So this is something that, again, I refer to it as the rule of 6. 6 months for any unaccepted offers. All other documents after that, 6 years. Okay. But again, in a practical sense, most people are just keeping it for 6 years, everything's mostly digital now. So I think that this is something that I'd say in 10 to 15 years, you're probably not going to see this be an issue anymore. However, I digress. We're not there yet. So keep in mind the rule of 6. Now, let's talk about advertising in the state of New Jersey. And let's talk about what you can and cannot do. So in the state of New Jersey, there's a couple of things that you want to make sure that you are well aware of in regards to advertising. The very first thing that you want to make sure of is that you are using your full legal name. If you want someone to call you a nickname or something of that nature, let's say your nickname is Toots Magoots, and you want to sit there and say, I want people to call me Toots Magoots. Well, you can't just put Toots Magoots Johnson on your business card. You would have to put Robert Toots Magoots in parentheses, in quotations, Johnson. Okay, you have to have your legal name on there, and especially there's sometimes legal names. There's sometimes ethnic names that are longer, that are harder to pronounce, all that kind of stuff. So I understand the shortening and maybe wanting to call yourself Toots Magoots, but you have to have your full legal name as it appears on the real estate license in all of your advertising. Second thing, I will tell you this: your brokerage name must be larger than your name. It doesn't matter. It could be half a point font, okay? It could be in a different color, and that's where people usually get away with it, and they usually make their name a lot more prominent than the brokerage name. There's reasons for this, and one of the reasons is the Real Estate Commission really wants the consumer to understand who they could go to if there is a concern, an issue, or a problem. You know, who is the responsible party for this individual, okay? So that's about it with advertising. And the next thing that I want to talk about, this is the last thing, super important, price fixing. Based on the Sherman Antitrust Act. They don't have it here. It's in your book, though, if you're reading out of the book that I'm teaching out of. The Sherman Antitrust Act says that you cannot price fix. So what is price fixing? Price fixing is basically saying there are two brokers and they collude on setting some sort of standard commission. In the state of New Jersey, in the United States of America, there is no such thing as a set real estate commission. There is no standard. So if you're having conversations with another broker on it or another agent, even if it's at a different state, and you're just talking about commission in general, you should probably stop. You should probably stop yourself and say this is not an appropriate conversation to be had, because this could be misconstrued as potential price fixing. This could be misconstrued as potential setting a climate where there is a understood standard commission. There isn't. Every commission is negotiable in the state of New Jersey and in the United States. I will tell you this: there are people who have business models that they just don't accept. They say we are a 2% company, we're a 4% company, we're a 7% company, whatever the state may, whatever the case may be. That's what they say. Business models are fine. It's fine to have a business model and to say, look, this is what we do. If you don't like us, you could go elsewhere. However, to collude with another brokerage or multiple agents to potentially try to set a standard or even suggest that there is one, that is illegal, and that's price fixing. And guys, that's chapter 2. Have a great one. And I'm going to tell you, hit that like button, hit subscribe. And if you haven't already, check out all the other videos. We'll talk soon.